Hey guys, what's up? Welcome to Lawsplaining the Interwebs, a special emergency live stream in this LoLsuit saga that's been going on between Maddox, Dick Masterson, and Asterios Kokonos. Today is a little out of what I was expecting. If you're not aware, last night. I did a live stream on Kevin Landau's response to Dick Masterson and Foundation Digital, and I thought that this document was going to come on Thursday, but it is here early, and it is like Christmas. It is Asterios' response to Landau's response to Asterios' motion to dismiss. It is drafted by Jay Greenberger, the attorney for Asterios Kokonos. And I have not read all of it, but from what I've read, this stands to be a fantastic live stream. I'll start answering those questions in the chat real quick. Let me do a couple things that I'm really bad at doing. First, please check me out on Patreon, patreon.com/lawsplaining. You can find all of the episodes that I do. There's bonus episodes for Patreons or Patreonies, whatever they are. There's bonus content for them and live content that is specifically reserved for them as well. Just check it out. You don't have to subscribe with money, but you can follow me on there and I believe get access to the audio feed of that. Or you can find me on SoundCloud, iTunes, or Google Play if you just search for Lawsplaining. So please subscribe to me on any of those devices. Some of these get really long, and I know the video format doesn't work for everybody, but the audio formats sometimes work really well. Another thing, so the way these live streams go, I try to answer any questions that pop up in the chat. The easiest way, the most effective way to get my attention is with a super chat, but I realize not everybody wants to dump money just to ask me a question, and that is absolutely fine. I'm 100% with it. Of course, I love super chats, but that's not the only way to talk to me. If you do tag me with using @Rekieta Law in the chat, it will flag me as well, and I will try and keep up with those. We have two quick questions. Matthew Reifler says, is Landau so terrible and predictable that Greenberger had it ready to go? I imagine that is likely the case. And then Patrick Lonergan says, who is playing Minecraft on my computer and which kid is the atheist? The person playing Minecraft on my computer would be my son, my oldest son, and none of my kids are atheists at this time. So, Windows 95 says, buy some Tullamore Dew. I've given you more than enough cash, you cuck. Also, I'm a drunk French woman. Also, I want to be Asterios' best friend, Amelie Hart. And Kevin Cartilage says, as a Kevin, you have my thanks for these live streams. To answer your question, Keck, I am not going to be, it's like 5 p.m. here, and I have, after this stream, I will be hanging out with my family, and I will be potentially having to drive and stuff. So I'm not actually going to drink any alcohol on the stream tonight, or today. I have cream soda from Sprecher, which is like a brewery somewhere in Wisconsin, which is good. Tango Man asks why this lawsuit is so amazing, and I think it's the personalities involved. Ryan Burns says, just try to stay a little calmer than you were last night. I will, buddy. This one is not going to be an anger. This is going to be just a joy. Coke or Pepsi, boxers or briefs, vanilla or chocolate, Star Wars or Star Trek, CBT or BBC. Kyler, Coke, boxers, vanilla, Star Trek, and neither. All right, guys. So yeah, so feel free to drop stuff in the chats, ask me questions as we go. But really, this is a bonus. Asterios' attorney has gifted us with 22 pages of gold, as far as I can tell. And we're just here to enjoy them. Oh, I'll bring this mic a little closer. All right. So, put down a towel in case. Yes, I already have a towel down. I'm wearing Depends, just in case I have to urinate in the middle of the stream from laughter. I wish this case would have jurors judging it. I would love to see their reactions. The best part is that some of these jokes will probably go beyond the judge. But you know, we'll see. We'll see. Man, so one more point of order before we really get rolling here. If by chance Greenberger or Matz or any of the attorneys involved, even Landau, even you, buddy, if you're interested, when I know you can't now, but when all this comes to a close, hopefully sooner, although it'll be sad, I would love to interview any and every one of you, because I think this has been fantastic. Most legal stuff can be pretty boring, but this is just given gift after gift after gift. Elijah Watson, please buy your family something nice with this for dealing with how much time you spend entertaining us. I will. Yeah, that is no doubt. No doubt that that's going to happen. All right, guys. That's enough of an introduction. Again, let me plug it again because I didn't plug it at all last night. Patreon.com/Lawsplaining. Check it out. If you like what I do, toss me $1. If you really like what I do, toss me more. But all of the stuff that all the interactions I have on there have been really great, and we have a lot of fun. So, Mike Romanzo, as a local New Yorker, I can confirm when I say this: the law and judges are comedic as most. Granted, the state is mostly blue downstate. Yeah, we'll see. We'll see what happens with this one. The reason I say that some of the jokes are going to go over their heads is because they're not doing the same amount of research that we're doing on this. And so there's a joke right in the first page that the judge may not get, but we'll see. Well, Tango Man, that's not how I roll, but you know, but the top gay can do what he will. Okay, anyway. So let's get into this document. Asterios Kokkinos, by his undersigned counsel, respectfully submits this reply brief in further support of his CPLR 3211A7 motion to dismiss the complaint. If you're not aware, that is a motion to dismiss for failure to state a claim, the failure to state a cause of action which a court can provide a remedy. This is one of the most common motions you'll find in civil cases, just because if you win it, you win. So let's see what happens here. Plaintiff Azunian is the subject of Mr. Kokkinos' lampooning right out of the gate. Just laying out the facts. But Mr. Kokkinos' alleged conduct is not tortious. That's true. He is simply providing humorous content on various platforms, and in doing so, he is entitled to poke fun at Azunian, as we all are. Windows 95 says, patreon.com/Asterios. Do is now whiskey of stream. And yeah, everybody, if for nothing else than to help him pay for Greenberger, go hit up Asterios on Patreon, because let's be real for just a minute. And not that I'm being fake at other times, but let's bring it down. Okay, let's bring it down to the reality of the situation. Nobody deserves this. Dick doesn't deserve this. Asterios doesn't deserve this. Madcucks doesn't deserve this. None of these people deserve this. But Asterios really doesn't deserve this. Right? This is at if there's anything even close to merit to any of this stuff, it's a dispute between Dick and Maddox. Asterios is just a guy making funny jokes, trying to make it, trying to do what he does. And he does it well, and he does not deserve any of this. So check him out on Patreon, listen to his comedy, buy his books. The guy's hilarious, and he's genuinely one of the nicer guys you'll find. And yeah, he just doesn't deserve this. Maddox is really a dirtbag for doing this, to him especially. So, all right. Let's get back to it. So he, being Asterios, is entitled to poke fun at orangutan. If orangutan is losing fans, that is not Mr. Kokonos' fault. And this is objectively true. George's content has gone just straight to garbage. The guy was funny decades ago. He carried that wave of funny for a while until we all realized that what he labeled satire actually appears to be his perception of reality. And it suddenly became less funny. I don't even have an analogy. But it's like, okay, it's like when you're laughing at that dog who keeps running in circles, but you realize the dog only has 2 legs on one side and no legs on the other side, and so he can only run in circles. That's what happened to Maddox. It was funny when we thought it was a joke. It stopped being a joke. Can you give me plastic bag milk? No. All of my milk comes in plastic jugs. Bag milk is weird. Canada is strange. Rather than sue Mr. Kokonos for the absurd amount of $20 million, Ozunian should accept responsibility for his declining popularity. Yeah, he absolutely should. Ozunian and Blub's opposition to Mr. Kokonos' motion is like a dog bite without any teeth. I mean, come on. That's brutal. See, these are the bants that I don't think the judge is going to get. But you know Landau will, and you know Maddox will, and it'll just be, oh, it's great. Plaintiffs pound on the table with a repetition of the complaint's allegations, general statements of law, and arguments based upon easily distinguishable cases and a mischaracterization of their own allegations and exhibits. But it is not necessary for Mr. Kokonos to dissect and rebut each and every issue in plaintiff's opposition papers. It's not, because most of the issues raised in the opposition papers aren't actually, they're not actually issues, and they're bringing new evidence or all sorts of things that the court is simply going to ignore. So I'm glad Greenberger addresses that and lays it out. Simply put, plaintiff's opposition papers failed to address many of the points raised in Mr. Kokonos' moving papers why the complaint should be dismissed. Even if the court accepts all of plaintiff's arguments, Mr. Kokonos has provided uncontroverted basis for dismissal. Further, permitting plaintiff's claims to proceed would chill the right of every New Yorker to criticize, comment, and joke about people who have placed themselves into the public spotlight. And this is an important point. Like, it's fun to joke about this lawsuit. It really is. Believe me, I have tons of fun laughing about this lawsuit. But the implications of Maddox winning, even getting past summary judgment in some ways, but Maddox winning, like, this is a First Amendment issue to its core. And the idea that someone could successfully sue for hurt feelings by being made fun of on the internet, especially a public figure, is offensive. It's offensive to the First Amendment, and this needs to be struck down immediately. All right. Invasion of privacy, civil rights law, section 50 to 51. Moving papers established that plaintiffs failed to state a claim for invasion of privacy under civil rights law 50 to 51. The statute does not protect California residents. Boom. And Mr. Kokonos' alleged conduct is First Amendment protected art, comedy, and criticism. Reaching to overcome the civil rights law's territorial limitations, both plaintiffs submit affidavits attempting to connect them with New York. Attempting. actually, I don't think Blum has successfully connected herself with New York in any tangible way, just saying that she does business in New York. But she didn't provide a date of any trade shows where she modeled or anything like that. Or a W-2. Wait, not a W-2. Any sort of tax return for the state of New York for any income earned there. By the way, if you're Maddox and Blum, if you're primarily doing business in New York, I hope you're filing your New York state taxes, and maybe the New York state auditor would want to look at that for their Department of Revenue, because if you're doing your business in New York, then you're getting paid under the New York taxing structure, and you might not be paying those taxes, buddy. At Clay, it depends. You know, if you're in Minnesota, I'll consider it. So let's see. Ozunian states that he is an author operating and conducting business in New York with a publishing contract with Simon & Schuster located in Manhattan. And Blumdoe states that she is a professional model and actress conducting business. Goodness. Conducting business predominantly in California and New York. Neither, however, states that he or she is a New York resident because they are, as pleaded, California residents. The New York statute does not protect California residents. Rogers versus Grimaldi, citing Southeast Bank N.A. versus Lawrence, and applying Oregon law because plaintiff Ginger Rogers was domiciled in Oregon. Cummings versus Soul Train Holdings, LLC, applying Illinois law to right of publicity claim by an Illinois resident. California, the state of plaintiff's residency, has a greater interest in compensating its residents for injuries of the type here alleged than New York may have in compensating non-residents injured within their respective borders. Clark versus Caleb Pub, Inc. Over and over and over, we have to just get, they have to just keep hammering the fact that Maddox does not live in New York. And while you can avail yourself of the jurisdiction, right? That's how you sue in a foreign jurisdiction. That's okay. You can do that. But statutes can still have territorial limits. And you don't get to overcome that with a false claim that you do some minor amount of business there. It doesn't work that way, especially when we're talking a residency requirement. Maddox doesn't spend time in New York, even if he does business in New York. All right. Ozunian and Doe Blum attempt to distinguish Sondic v. Kimmel, but the foregoing authorities confirm that plaintiffs, as California residents, are not protected by the New York statute. Plaintiffs also ignore that, even if the statute applies to California residents, use of their name and likeness alone does not create liability. New York law is clear that the use must be for advertising or trade only. Here, Mr. Kokonos' alleged conduct is not solely for advertising or trade purposes. Instead, Mr. Kokonos' alleged conduct constitutes comedy and satire. Works of art like the Santa Cuck album. Works of art like the Santa Cuck album. Like, what timeline did anyone foresee reading that sentence in a court document? When I turn my head to the right, the audio being louder on the left goes away. Hey, help me out here. I'm just going to throw my keyboard away. How about now? Does this fix the audio issues? Does this get the audio nice and centered for everybody? Corey, if you can answer that for me, if that helps, since you seem to be on the stereo game here, let me know. I just moved the mic and realized I don't need a microphone at all. All right. I'm going to let's get into this. Here, Mr. Coconut. Yeah. Works of art like the Santa Cuck album poking fun at Ozunian do not fall within the narrow scope of statutory phrases, advertising, and trade. Hampton versus Guar and Altback versus Coulon. Even if Mr. Kokonos is allegedly making money from his works, like the success of the Santa Cuck album and on Patreon, his conduct is not, quote, strictly limited to a commercial appropriation. That's Walter versus NBC Television Network. There are countless media outlets in New York that lampoon famous or semi-famous. Like, I don't know if that's a subtle jab, but that's the subtle jab I would do. People without being subject to liability under the civil rights law, e.g. Saturday Night Live and Mad Magazine. Absolutely. Absolutely. Or I don't know if National Enquirer is in New York, but National Enquirer, any number of small-time publications that are all over in New York City. I mean, of course people make fun of people. Like that's just part of being an American. I mean, okay. Let's move on. The cases upon which plaintiffs rely are distinguishable. In Onassis versus Christian Dior, the defendants used an actress appearing to be the former First Lady on a print advertisement for Dior, which was published in various newspapers and magazines for the sole purpose of selling luxury goods. Yes. And again, Dior was used as a positive endorsement of the product. That's part of it. It's not they weren't promising that when you buy their goods, they were going to gossip about Onassis, right? What they were doing is trying to make it look like Onassis would use their product. That's the appropriation that the statute contemplates. I can't say it enough. Because Landau won't listen. There's an interesting question in the chat. Chris Clemson asks, has Weird Al ever been sued other than by Coolio? I'm not sure if he has, but I know Weird Al asks every artist that he parodies before he does it, even though he doesn't have to. He gets permission, but he doesn't necessarily need that permission. Unless he's making a music video. Actually, yeah, covers, just vocal covers are this weird sort of license that doesn't require permission from the artist. You can kind of read about it. I can't remember what the license is called. It might be something weird like a mechanic's license, but yeah, it's pretty interesting stuff. Okay, in Ryan versus Volpone Stamp Company, a famous baseball pitcher's name, I'm guessing that's got to be Nolan Ryan. Andrew Gluck, if you're in the chat, verify that for me. Likeness and signature was used on various items of memorabilia. Mr. Kokonos is not using plaintiff's name and likeness solely to sell goods or products. Nor is Mr. Kokonos exploiting nude or sexual images of private individuals, as was the case in Leviston versus Jackson and Myers versus U.S. Camera Pub Corp. Both cited by plaintiffs. Kev the lawyer, is it... So when are you sober? Instead, Mr. Kokonos' alleged conduct is critical of a self-described internet personality, a New York Times best-selling author, which, man, he wields that every time he can, right? With allegedly hundreds of thousands of subscribers to his content, dropping by the day. Thus, even if the court does not consider the communications as comedy or satire, Mr. Kokonos' alleged conduct nonetheless falls within broadly construed exception to liability for newsworthiness or public interest communications. And that is that's something that's glossed over in Landau's motion, right? He tries to address the newsworthiness, public interest, comedy, satire exception, and he says that that's a jury question. It might be a jury question, might be, but the exception is broad because the First Amendment is sacrosanct in this country. Like, and the fact that there's a lawyer out there trying to snuff out First Amendment protected speech is a disgrace to an already relatively disgraced profession. And he should be ashamed. So there's a footnote here. Plaintiffs misidentify the block quote in Onassis versus Christian Dior as a statement by the First Department. Plaintiffs actually quote from the lower court decision, which was affirmed by the First Department in a 2-word summary affirmance. Plaintiffs similarly misidentify Leviston versus Jackson Infra as a First Department decision. And I mean, at this point, are we surprised? Are we surprised at all that Landau is being shoddy in his work? I'm not. All right. Defamation. This one's good because this is the worst. Like, this is one of the worst claims Maddox has. I mean, I don't know. Actually, it's hard to quantify which is the worst claim of Maddox. Defamation. Allowing the claim to proceed would chill Mr. Kokonos' First Amendment right of free speech. If you don't know, like the chilling effect is it's a legal term of art. It means that there's basically a prior restraint or, stopping speech before it even happens because people are worried about the consequences more than they are concerned with making their own speech available for other people to hear. So chilling effect is hearkening back to a specific case, which I'm not going to remember off the top of my head. Not drinking enough to remember specific cases, apparently. Plaintiffs ignore that they are, according to their own allegations, public figures. An internet personality and best-selling author, Ozunian, and his girlfriend, Doe Blum, who is a model and on-camera co-host in many of Ozunian's videos and live streams. James V. Gannett Company. Having put themselves in the spotlight, plaintiffs cannot now complain about being the butt of Mr. Kokonos' humor. And then he cites Frank versus National Broadcasting Co. And generally Salamone versus Macmillan Pub Company, describing when humor may be a defense to a suit in libel. Further, as public figures, plaintiffs were required but failed to allege facts sufficient to show actual malice with convincing clarity. Yeah, because, okay, so there's, when you have a defamation claim, you need to have a knowingly false statement, and you have to put forward that knowingly false statement. It has to cause damage, and the damage has to be caused by the false statement, and that damage has to be fixable by the court. That's kind of the 4-part test for defamation. When you get a public figure involved, you have to knowingly publish the false statement, knowing that it's false and intending the falsehood to cause damage. So that's the actual malice. Like, it's not enough to just know that the statement might be false. It's not enough just to publish a false statement. You have to know that you have to intend for that false statement to cause damage to the person. So this is how public figure defamation works, and that's Jimenez versus United Federation of Teachers. Plaintiff's bald and conclusory malice allegations are insufficient. Indeed, the allegations that Mr. Kokonos is acting out of economic self-interest to unfairly compete with the Zunion contradicts the notion that actual malice is his sole motive, right? Because, yeah, if he's solely motivated for malice, then he wouldn't care about the money he's earning. So we have contradictory legal theories happening. Additionally, the complaint fails CPLR Section 3016A's heightened pleading standard for defamation because it does not identify with any specificity the allegedly defamatory statements made by Mr. Kokonos. And this is a problem with Maddox's entire claim. All of it is a problem because there is no specificity. The quotes that are specific are typically attributed to other people or are facially non-actionable. And then everything else is just a sort of general malaise that they're trying to accuse someone of. They're trying to accuse Dick and Asterios and Mad Cucks and Foundation Digital and Patreon, everybody. There are all these generalized statements. There's nothing pleaded with particularity, but the court can't rule on like just this general fog of potentially tortious conduct. They have to know what the tortious conduct is because all of this stuff is fact specific. In opposition to the motion, plaintiffs attempt to cure this defect by submitting Appendix A and Exhibits 2 through 17. Even assuming arguendo that plaintiffs can cure CPLR Section 3016A issue in opposition to the motion, the additional materials confirm that plaintiffs do not state a defamation claim against Mr. Kokonos. So here's why he's saying even assuming arguendo that they can cure it is because the motions that are supplied here and the memorandums that accompany them are not places for new facts. The motions and memorandums are places are you can restate the factual statements that you made in the complaint, but they're actually for matters of law. They're for legal reasoning and legal arguments. They're not a chance for you to introduce a bunch of evidence that you just failed to introduce in the first place. This is not your do-over, Landau. And the fact that he's trying to throw so much additional evidence, all of which was available at the time of the filing of the original motion. See, that's one of the exceptions, is if there was information out there that they could have or couldn't have gotten before or couldn't have known, then maybe you can add that additional information, usually with permission from the court. But if they don't have that, you don't get to add new facts to these motions. The motion to dismiss should and likely will be heard on the merits of the complaint itself and then the legal arguments of the motions and counter motions that have come through. Mr. Kokkinos is not liable for other people's communications. Many of the allegedly defamatory statements were made by other people. Yep. As alleged and confirmed in the exhibits, the statements were made by fans of the Dick Show podcast, death and rape threats, joke by the Reddit user Madcucks that post dates the commencement of this action, a post by the Reddit user Lpup, Herrera, horsecock comment, targeted online advertisement, caricature of Azunian on a poster, calling Azunian a liar. So this is an interesting thing. And this is probably why, just sort of some inside baseball here. This is probably why Dick and Asterios had to get separate attorneys, right? Because part of Asterios' defense is going to be that Dick said that, not me. I didn't say that. Dick did. For example, that's laid out right there. Dick made the caricature of Azunian on a poster. Sure. Or Dick commissioned it, one of those two. So that action can't be attributed to Asterios. If it's attributed to Dick, that's Dick's problem, maybe, if the court has jurisdiction over him, right? If it's actionable in the first place. That poster, I believe, only was circulated physically in California and then was just generally posted online for a show in California. So that's really not an actionable thing anyway. But because of this, there's a potential conflict of interest in having the same lawyer when you are operating under a different legal argument or a different fact set than someone else. So part of Dick's defense is that Asterios made the Mad Cucks album, Dick didn't. So if anyone's wondering why there are multiple lawyers and the parties are kind of separated out into these little camps, that's why. That's the main reason, is because there may come a point where you have to throw someone else under the bus, and it's not personal. It's just part of sound legal strategy. You see this a lot in criminal cases, actually. I didn't do it, he did it, and the other guy says I didn't do it, he did it. And then they sometimes can both get off for a crime that they both committed by blaming it on the other person. All right. So unknown and unidentified people who are not alleged to be Mr. Kokkinos and who Mr. Kokkinos is not. A parody advertisement. Exhibit 15, not pleaded in complaint and previously unseen by Mr. Kokkinos. Plaintiff's agreement that the horsecock comment and cuckway parody advertisement impugns Doe Blum's chastity by implying that she has sexually transmitted diseases is academic. Those statements are not attributed to Mr. Kokkinos, and Mr. Kokkinos did not first post on the Kiwi Farms until months after the alleged advertisement. Additionally, even if Mr. Kokkinos had made those alleged comments, the cuck statements cannot reasonably be interpreted as referring to Doe Blum. Three Amigos SJL Rest Inc. versus CBS News. If the court adopts the proffered dictionary definition of cuckold, further discussed below, the unfaithful romantic partner could be of any of Azunian's prior partners, i.e. not solely his girlfriend, quote, at most times alleged in the complaint. That's a brilliant point. Windows 95 says, give Nick cash, you peasants. Tully do stream whiskey. Thanks, buddy. All right, so there's a footnote here. Plaintiff's opposition brief at page 17 misquotes their own allegations in paragraph 26 of the complaint. Plaintiffs do not allege that Mr. Kokkinos made the statements calling Ozunian a liar who supported rape. And I mean, misquoting yourself has got to be the height of just poor form and poor drafting. Jaime says, can Maddox drop the case at any time? Why would he willingly run himself into debt and humiliation? That second question is anybody's guess. Can he drop the case at any time? Pretty much. But the court may decide that bringing the case in the first place, especially at this point in time when people have sunk so much money into defending themselves, that he maybe could drop the case, but he might be subject to those attorneys' fees. It's a good question, but the court may not let him just drop it at this point without some sort of penalty, because you don't get to go in and cost people tens of thousands of dollars, and then just say, you know what? I was only pretending to be retarded, right? Like, that doesn't work that way. Clay Early, make us drink for something, Rekieta Law. Clay, I don't know the rules of the drinking game, buddy. So I will try. So thus, Matherson versus Marcello, cited by plaintiffs, is distinguishable because the statement there specifically identified the allegedly unfaithful person as the plaintiff's wife, who is an identifiable person even if not specifically named. Notably, Blum opted to originally identify herself as Jane Doe, which reflects her belief that her actual identity was unknown. Mr. Kokkinos, similar, cannot be liable for the Mad Cucks character because he is not Mad Cucks. Defendant Bird is Mad Cucks. I mean, but Asterios, I think what you may be forgetting is that you and Dick not only created Mad Cucks, but you also literally created Bert as well. He is the product of your love affair, and one of you owes some serious child support to the other. And both of you owe Mad Cucks, I think, some money for college or like a sweet car or something like that. Be good dads. All right. If the court accepts plaintiff's allegation that Mr. Kokkinos co-created the character with Burton Herrera, in fact, he did not. Oh, and then there's a footnote, and I'm going to go straight to it. Plaintiffs argue that a Reddit comment post-dating the lawsuit confirms that Mr. Kokkinos created the Mad Cucks character. Mr. Kokkinos did not, however, create the character. Moreover, the comment is clearly a joke responding to the main post describing as humorous, in words and pictures of laughing celebrities, plaintiff's allegation in the complaint about the Mad Cucks character. Fans of The Dick Show have begun referring to this action as the LoLsuit. Guys, we made it. Laugh out loud. And there are numerous fan posts on Reddit commenting on the papers filed in this case, both seriously and in jest. Indeed, there are even other lawyers, not representing any of the parties, who have streamed videos and posted statements commenting on the papers. We did it. The only thing that I wish Greenberger would have put in was like a link to my YouTube page for the judge. Next time, friend. Plaintiff's argument that the character constitutes defamatory impersonation is belied by their own description of the character as a parody of plaintiff. The character does not purport to actually be Ozunian. Ben O'Leal versus Press Pub. Plaintiff stated a claim for putting in her mouth or attaching to her pen words which were libelous. Franklin versus Daily Holdings. The sole impersonation case upon which plaintiffs rely is distinguishable. In Raw versus Hellman, defendant intended the fabricated email in the plaintiff's name to appear as though the plaintiff were the speaker. Right. That's because impersonation and parody are two vastly different things. One is meant to cause confusion to the audience. No one thinks that Mad Cucks, the character, is Maddox, despite how spot on the impression is. It's not an impersonation. It is a comedic impression or a parody. These are vastly different things in a legal standard. And Raw, yeah. So here, plaintiffs describe the character as slovenly dressed, slow, dim-witted individual with a speech impediment common to people with Down syndrome and characteristic of a person with disabilities. And again, I will say disabilities is a bit strong. It should be differently abled persons. So some idiot says, Mr. Rackets, is there a reasonable chance that a judge would hold the colorfulness of the response in a negative light? Probably not. As long as the colorfulness remains on point, having some jabs at the other side, especially given the lack of integrity displayed by Landau and Maddox up to this point, there's no way that they would hold sort of the mild levity in this document to be negative. Windows 95, visit Learning with Leon on Facebook, official Nick endorse. Yes. I officially endorse visit Learning with Leon on Facebook. Okay. Plaintiffs clearly are not alleging that Uzunian shares those traits or that the character so resembles him to the extent of deceiving the audience as to who is actually speaking. Mad Cucks isn't even Armenian or bald. None of... Nor is he banned from Apple stores. No one reasonably believes that Bert's Mad Cuck's character is actually Uzunian because the character is, as described by plaintiffs, a parody. Calling Uzunian a cuck and a scumbag is non-actionable opinion. Which is good, because scumbag is one of my favorite insults. Mr. Kokonos did not defame Uzunian by calling him a cuck, a cuckold, or a scumbag. And allegations about the Cucksmith Carols album, those statements are non-actionable opinion. Calling Uzunian a cuck and a scumbag are general insults, like calling someone a clown. Dupuy versus St. John Fisher College. Obnoxious. Baum versus Karp, Silver, Glinkenhaus, and Flaumenhaft? Wow. Incompetent. I'm glad incompetent is just a non-actionable opinion because Landau is highly incompetent. A bastard, Klein versus Rathheim, or a bum and a tramp. Asterios, if you're watching this, pal, and you do another album, I hope you take this list of non-actionable opinions and weave them specifically into a song. If the court substitutes cuck with jerk, it becomes plainly apparent that Mr. Kokonos is merely expressing his subjective opinion about Uzunian. Bazinga Boys asks, do you think the high level of zingers in this response is just Greenberger wanting to get you to laugh on this stream? I hope, and you are there. I see you, buddy. I hope that Greenberger watches my stuff, and is just trying to get me to laugh. But I mostly hope that Greenberger is competently representing Asterios, which he seems to be doing. That's my primary concern. Comedy is a close second. Further, when viewed in context, Mr. Kokonos' alleged statements suggest to a reasonable person that he is merely expressing an opinion. Tarati versus Hodak and LeBlanc versus Skinner. The tone of Mr. Kokonos' statements, as well as his role as a comedian appearing on the Dick Show podcast, which is a comedy podcast, make it clear that the statements were intended to be invective in the form of humor. Again, like under this, like the idea that this would be illegal, like Howard Stern would be thrown out. Like he could not exist as a persona. People like Bill Maher could not exist in this fantasy world that Maddox has created. The massive broadcasters who take time insulting people, who make jokes, who are clearly who disagree with someone, like the Daily Show. The Daily Show insults people based on their opinions on a daily basis, right? These things can't exist in the sad world that Maddox has tried to paint. The dystopian nightmare that is a cucked future without comedy. Plaintiffs attempt to overcome this issue by adopting the dictionary definition of cuckold as a man whose spouse or romantic partner is unfaithful. But the term's defamatory meaning is to be judged by the average and ordinary reader, quote, acquainted with the parties and the subject matter, i.e. the specialized audience who are fans of the Dick Show and Mr. Kokonos' comedy, which is Jean Lecage. I have no idea how to pronounce that, versus Sot. My mic is... Oh, you got me. You got me. Jason Benaim, my mic is muted. Thanks, bud. To fans of the Dick Show and Mr. Kokonos, a more appropriate definition of the term cuck is one that Mr. Kokonos' employer, Weber Shandwick, offered. An insult frequently used on the internet where it has become shorthand for any perceived weakness or rather perceived reluctance to exploit strength. And I mean, this is a good point because if if you're trying to attach like some sort of random agency to a principal agent relationship to Asterios and Weber Shandwick in a bald attempt to rope a major corporation into a fake settlement, you coward. By the way, I don't know if I mentioned before, but Landau has a history of attempting to improperly join parties to lawsuits and has lost on that issue over and over again. But if you're attempting to create some sort of principal agency relationship between Weber Shandwick and Asterios, then you would have to assume that Asterios would be using the company-friendly version, definition, I should say, of cuck. So an insult frequently used on the internet, which is where it's being used, by the way, where it has become shorthand for any perceived weakness or rather perceived reluctance to exploit strength. Had Asterios driven by Maddox in his horse-drawn carriage in a powdery wig and called him a proper cuckold with an English accent, maybe we could go to an old English dictionary definition of the term. But yeah, not in this case, obviously. Using this definition, how could Azunian possibly prove that Mr. Kokonos' opinion of him is false? If the court does adopt the dictionary definition, it nonetheless still is critical to understand the temper of the times and the current of contemporary public opinion. That's Nolan versus State. Infidelity is prevalent in today's society, such that the term cuckold does not have the same impact as it may once have. Once may have. Wow, I went dyslexic there. To that end, Azunian himself has stated that there's nothing inherently wrong with being a cuckold. Right, Maddox? Hope you're wearing that cuck shirt, buddy. Cuck. Nothing inherently wrong with it. Jeff Pierce says, give Nick monies. And I agree with Jeff Pierce. There's nothing inherently wrong with being a cuckold. It can't be defamatory if you don't think it's wrong. See, You Don't Know What a Cuck Is, published by Azunian on YouTube on May 16th, 2016. Oh, man. Whew. Azunian has manufactured an argument for the term cuckold, that the term cuckold is defamatory for the purposes of this lawsuit. He doesn't believe it. He has ardently defended the idea of being a cuckold. It is not okay, Maddox. Lastly, if this case proceeds beyond the pleadings, Mr. Kokonos intends to prove that Azunian is, by his own dictionary definition, a cuckold. That is brutal. That is brutal. The genesis of Herrera and Azunian's falling out was that Azunian's ex-girlfriend cheated on him with Herrera. It is axiomatic that truth is a defense to defamation. There are numerous other examples of truth as a defense. For example, the lyrics of Mr. Kokono's Little Cuckold Boy song are based on things Azunian actually stated. Mr. Kokonos has the transcripts. And other provable facts, like Azunian being bald and a quote writer. Oh, oh, I wish he would have put in brackets a sigh after the writer comment, but oh my goodness. Plaintiff's allegations that the statements are false border on frivolous. Oh my goodness. Guys, so they cite Almasiga versus Center for Investigative Reporting. Let me just take a minute. And let you know what Greenberger did here. I'll read the caption. Plaintiff's counsel in this action represented a plaintiff who was sanctioned for perpetuating a fraud on the court by pressing allegations that she knew to be false. Kevin Landau was the attorney in Almasiga versus the Center for Investigative Reporting. Kevin Landau perpetuated a falsehood that was known to be false and narrowly avoided sanctions. He also improperly attempted to join Univision to the action for merely airing the documentary that Univision had nothing to do with producing. They fired their first expert witness, probably because the expert witness wasn't confirming it. They hired another expert witness. I do have a video planned, but the opinion from the judge in this case is 65 pages of a judge telling Landau he's wrong. And Greenberger drops it right in there, right on him. Beautiful. Some idiot, will I hire a 1L to research comedy bits for you? They better be a talented 1L. But maybe. Clay, as my lawyer, can you tell Asterios to drink? I can tell him to. It'd be better in a letter. We should demand it. All right. The targeted advertising campaign allegations. Mr. Kokonos' alleged statements are not defamatory because they are about the mechanics and cost of operating the advertising campaign. Such statements do not tend to expose plaintiffs, quote, to hatred, contempt, or aversion, or to induce an evil or unsavory opinion of the plaintiff in the minds of a substantial number of the community. Golub versus Inquirer Star Group. So again, yeah, when he talks about running out of spite money and all that stuff, that's talking about the advertising campaign, and they're not actually defamatory statements against Maddox. Wow. Unfair competition. Someone get a fire extinguisher to Greenberger's office. The man is cooking. Plaintiff's opposition papers offer little else than referring to their allegations in the complaint that defendants collectively used and or passed off plaintiff's name, image, photograph, and or likeness. Plaintiffs completely ignore Mr. Kokonos' argument that the claim premised upon the alleged misappropriation of plaintiff's name and likeness is preempted by the civil rights law, the one that they're suing under prior to this. Section 50 and 51. Windows 95 says, visit bun posting and a girl marry me. I'm so lonely. Aw, man. If you weren't where you live in the place that uses pounds for money, and you were in the place that uses pounds for weight, like a proper unit of measurement, I try and help you out, pal. All right. Okay. So yes. It's preempted by the civil rights law. That's section 50 and 51 that they talked about earlier. See, New York has section 50 and 51. I know I've covered this, but in case you didn't catch it before, in the statute, it says that this is the only protection for the uses of name, image, and likeness. That there is no common law claim of privacy, and there are no other statutory methods by which to assert that there's some sort of misappropriation. So this is preempted by their own claim. Plaintiffs have no property. So it's sorry. The case. See, also the case is cited in Herrera's moving memorandum of law. Plaintiffs have no property interest in their image, portrait, or personality outside the statutory protections granted by the civil rights law. Plaintiffs do not identify, either in the complaint or in the opposition papers, any other property or commercial advantage allegedly misappropriated by Mr. Kokkinos. Unlike the cases cited by plaintiffs, this is not a case alleging the theft of trade secrets or proprietary information, case like in Link Company Incorporated versus Fujitsu. The theft of confidential customer lists like this Continental Dynamics Corp versus Cantor, or the theft of exclusive contractual rights in a trademark and product line like in Macy's Inc. versus Martha Stewart Living Omnimedia. Wow. Martha Stewart Living Omnimedia. That seems a little pretentious. Inasmuch as plaintiffs attempt to rely on the alleged targeted harassment campaign against plaintiff sponsors and book, Mr. Kokkinos is not alleged to have stolen those items to use for himself in order to compete against plaintiffs, or to have reaped the benefits of Azunian's labors and skill. The benefit Mr. Kokkinos allegedly has received is from criticizing and joking about, not misappropriating, Azunian's alleged skills and labors. And alleged skills and labors are probably true, with how long it took him to write a book that he had written decades ago. There's some alleged labor occurring, and certainly some alleged skills. At best, Mr. Kokkinos is alleged to have stolen Azunian's fans. Fans are members of the public, and Azunian does not have an exclusive property right to his fans or how they spend their time and or money on entertainment. If they, like, guys, think of the irony here. Maddox is arguing for a corporate protected state where once you are the fan or customer of a particular corporation, that corporation owns the rights to your patronage. Like Maddox is arguing for a corporatist oligarch, omnigarchy. I don't even know what it would be called, where our corporate overlords get to decide what we get to consume simply at their whimsy. That's Maddox's argument here. Good job, Maddox. Good job. I know you hate the free market, but I didn't think you were for a corporate state. Citing Michael Anthony Jewelers Incorporated versus Peacock Jewelry Incorporated, jeweler did not unfairly compete by providing cocaine and prostitutes to its employees and customers in order to bolster sales and foster loyalty. Look at that. Like, outside of this lawsuit, that sounds fantastic. You know what we're going to do? We're going to give our employees and our customers cocaine and hookers. Archie Comic Publications Inc. versus American News Corp. Distributor of Archie comic book did not unfairly compete with publisher of Archie by distributing two other thematically similar comic books. Fishmonster, I think I have to. I've got to find that case. Michael Anthony Jewelers Incorporated versus Peacock Jewelry Incorporated. Man, that sounds great. Fictional infliction of emotional distress. I'm going with fictional there. Calling Azunian allegedly insulting names and creating a comedy album making fun of him does not rise to the level of outrageous and extreme conduct going beyond all possible bounds of decency. Murphy versus American Home Products Corp. and Harville versus Louisville Central School District. Our society does not merely tolerate such conduct. The United States Constitution, Article 1, Section 8, Clause 8, encourages the promotion of the arts, and criticism of public or quasi-public figures is essential to healthy civic debate. Dropping the Constitution straight on Maddox. Oh, great. Plaintiffs assert that they nonetheless state a claim because the alleged conduct is part of a campaign of harassment or intimidation. Someone was not paying attention in their intentional infliction course. Nader versus General Motors Corp. Even assuming arguendo that the complaint contains sufficient allegations of a campaign, plaintiffs still fail to state a claim because the conduct that is allegedly part of the campaign was not conducted directly at the plaintiffs. Mr. Kokkinos is not repeatedly calling or emailing Azunian to call him a cuck or doing anything else directly to the plaintiffs. Like that's something that's been missing from this lawsuit. I harped on it a little bit on the last stream, just a few hours ago, it seems, that Maddox and Blum block everybody on every social media platform. Blocking them or just walking away from the computer screen is a bar to any of the behavior that's occurred. No one is making phone calls to them, spamming emails at them, delivering threatening packages or letters, at least not that I know of. And I certainly don't think that Asterios would be participating in that. Madcucks asked, does arguendo mean what I think it means? Arguendo just means for the sake of argument. Oh, it was already answered. Sorry. Yes, arguendo just means for the sake of argument. I apologize for not making that clear sooner. But yeah, they just, what was it? Tyler, the Creator's tweet, like, just close your eyes, just turn off the screen. Mr. Kokonos is not repeatedly calling or emailing Azunian to call him a cuck, although that would be funny, or doing anything else directly to the plaintiffs. He's allegedly putting his thoughts and creative expression into the universe on various media platforms, broadcasting it straight to Jupiter. Accord, Schotstein versus Silverman. Dismissing claim premised on the defendant's investigators' alleged defamation of the plaintiff's doctor in a report to the workers' compensation insurer. His alleged statements were not made to the plaintiffs, nor was his conduct directed at them. His conduct is analogous to Saturday Night Live, repeatedly lampooning people in the public spotlight. Absolutely. Absolutely. To the extent that the claim is premised upon death and rape threats towards Blum Doe, Mr. Kokonos is not alleged to have made those statements, nor is he identified in the exhibits as the speaker. Joe Conley asks, Rekieta Law, you've read more court docs than I have. Have you ever seen the word bald so frequently used, or is that some sort of special legal term? I haven't personally seen it as frequently used as it is in these documents, but it is a legal term, just meaning, like without basis, right? Without foundation, without follicles. Stram versus Farrell. Dismissing claim against defendant wife who did not participate in or condone her defendant husband's outrageous conduct. In fact, on February 12th, 2018, an individual named Jesse Radden emailed Herrera admitting, in May and June 2017, I used several Facebook and YouTube accounts and sent aggressive and threatening messages, death threats, to people, including Jessica Blum, Metal Jess. I do not have a rational reason for my actions. I hope this email helps in getting everything sorted out for all parties, and I would like to apologize. Whoa. I assume this is the infamous Mr. Berger email. If it's in the appendix, I will absolutely read it. Yeah. Wow. So for those of you who aren't familiar and who aren't following on the Reddit, some of the Redditors, I think specifically AIDS Jesus, has linked pretty much every threat contained in the complaint to one guy or one guy's associates. That guy goes by the name of Mr. Burgers. Moderator says that the email is exhibited on the last page, which I'll get to. Absolutely then. Mr. Burgers is the, if people are not familiar with the lore of the Dick Show and the biggest debate or whatever, best debate, when they had the biggest problem, they did a couple live shows on YouTube, and a guy commented, get raped. And it became sort of a running joke for the show. A running joke that, if I remember correctly, Maddox brought in as a funny comment. And Maddox was not opposed to the get raped comment. He seemed to take amusement to it, and it became a long-running joke. Actually, probably for at least 6 months to a year after the start of the Dick Show. And biggest or best debate, it persisted as not an actual rape threat, but simply a comment that went on. And it all started with one guy, Mr. Burgers, and then it seems like Mr. Burgers has admitted to much of this behavior, and I know AIDS Jesus has done a lot of work in linking that to him specifically, linking pretty much all of the comments that can be traced to him in some specific ways. Check it out on the Reddit. It's interesting stuff. Okay. So we will get to that email at the end of this document. Absolutely. So moving on, tortious interference with contract. Canceled. That is, holy cow. I didn't realize what was doing. That's the entirety of the argument against the tortious interference with the contract claim. Like, they're citing the complaint. Canceled. Harry's canceled their contract. You can't have tortious interference without breach. Canceling is not breach. Canceling a contract is distinctly different from breach. So just boom, canceled. Gauntlet thrown. Greenberger is hilarious. Ozunian alleges that a sponsorship agreement with Harry's, the men's grooming company, was canceled. Unless the court accepts Ozunian's inconsistent boilerplate allegation in paragraph 165 of the complaint that the contract was breached, the court may reasonably infer that Harry's exercised a contractual right to terminate the sponsorship, and therefore there was no contract which was breached, and that could serve as the basis of a tortious interference with contract claim. To that end, Ozunian's publishing contract clearly was not breached because his book was published, and he states in his affidavit that he has a, quote, publishing contract, nor are there any allegations that Doe Blum had a contract which was breached. This is all very good. I want to state, not sure. I think I might have stylistically gone a bit further to state that, that he had an opportunity to produce the Harry's contract. He had an opportunity to produce the Harry's contract in an exhibit in his initial filing and chose not to. And that supports the inference that there is no breach, because if there was a breach of a specific clause of the contract, we would be able to see that, and they could show it, and they should have shown it, and they chose not to. Garrett Snyder, boilerplate is a term of art meaning just sort of standard language that goes into a document. So when you see like a mortgage document, it's like 30 pages. Some guy didn't write all that yesterday for you to sign today. He took a bunch of boilerplate language and then which apply generally to contracts of a particular type, and then you modify certain sections of that language to fit specific scenarios. That's kind of the distinction between boilerplate and I guess the rest of a contract. As a point of note, boilerplate language is typically less favored than specifically negotiated language, because someone, when the parties negotiate, leaving in something that just looks kind of like standard issue means that it was probably not overly contemplated by either party, and boilerplate language can be overcome that way. It's rare because it's still in the contract, but and it depends on the sophistication of the parties and everything. But sorry, that's a tangent on what boilerplate is. Confirming that plaintiffs do not state a claim against Mr. Kokonos, are plaintiffs' allegations that Harry's decision to cancel the sponsorship, quote, was based on the targeted campaign directed by defendant Herrera, not Mr. Kokonos, and that fans of the Dick Show, not Mr. Kokonos, were the ones who contacted Harry's. He did not direct the alleged campaign, he being Asterios, and he did not communicate with Harry's. You're right, I am getting hoarse. Because Mr. Kokonos' alleged conduct was not directed at Harry's, he cannot be liable for tortious interference. And he has several citations. Plaintiff's opposition papers do not address this line of cases. Kendall and Hyde is another sponsorship agreement allegedly interfered with. But this alleged contract suffers from the same defect as the Harry's agreement. Mr. Kokonos' allegedly tortious conduct was not directed at Kendall and Hyde, it was directed at fans of the Dick Show. Plaintiffs failed to state a claim for tortious interference with any contract. Also, I think Kendall and Hyde's sponsorship ended when they went out of business because they were just a fraudulent front business that wasn't actually delivering the products to the people they were fleecing money out of. Twice as much if you count the cows. Does Asterios' lawyer moonlight as a comedian? This is great. I hope so, man. Greenberger sounds hilarious. Tortious interference with business relations. loosely identifying fans, developers, and other individuals and companies as persons with whom Azunian allegedly had an expectant business relationship is insufficient to state a claim. Absolutely. You have to talk about the specific business relationship. Some idiot. Yeah, this is Sprecher cream soda. Very good. Good stuff. Azunian was required to identify with specificity something lacking in every aspect of this lawsuit. The people with whom he allegedly had a reasonable expectation of business relations. That's citing Rondo versus Houston and Business Networks of New York versus Complete Network Solutions and Clapper versus Graziano. Lacking specificity in the complaint, plaintiffs argue in their opposition papers that the subject relationships were with Kendall and Hyde, his girlfriend, and a newly identified sponsor, Candid. Separate from the issues of identifying in opposition papers previously unalleged relationships as a basis for the claim, Azunian wholly fails to address a fatal defect with his claim. Plaintiffs were required to allege that Mr. Kokonos acted for the sole purposes of harming Azunian, which... fatal defect because obviously his purposes have been to make comedy and entertain people. Ultimately, plaintiffs allege that Mr. Kokonos is acting out of regular economic self-interest by soliciting funds on Patreon and selling the Billboard and iTunes charting Santa Cuck album. Notice the proper spelling of iTunes. In plaintiff's own words, Herrera and Kokonos have created a lucrative business off these campaigns. In Exhibit 4, plaintiffs attach Reddit posts in which Mr. Kokonos is identified as requesting money on his Patreon account, quote, so I can recoup my huge losses on this costly prank. Absent the requisite state of mind and any other viable tort claim, plaintiffs do not state a claim. Conversion. Initially, plaintiffs do not address Mr. Kokonos' arguments that the claim should be dismissed for failure to demand a return of the property, which was refunded by Mr. Kokonos, a required element of a claim for conversion. So again, Landau has failed in the basic elements of the action. You have to request that property be returned. That return has to be refused. Part of conversion is using something to the point where the person who owns that something cannot use it to the exclusion of their property interest in it. This is why you can't why it's really hard to do digital conversion. Because if you just take a copy of something, you're not preventing their use in it. And I ranted about this last night. So, I don't know. Mad Cucks, when this is all over, should we do a bonus episode with everyone and talk about the lawsuit in full? Absolutely. That's a great idea. That is a great idea. All right. They could not demand a return because fans are not the type of property that may be converted. And again, Maddox, people are not property, especially since the 13th Amendment. Please go and take your archaic ideas back to 1864 where they belong. The plaintiffs instead copy and paste paragraphs 172 and 175 to 76 of the complaint in an effort to rebut Mr. Kokonos' argument that the conversion claim should be dismissed for failure to support the claim with factual assertions of specific wrongdoing. Still conspicuously absent are any details as to when, where, or how Mr. Kokonos allegedly converted these items or otherwise participated in a conversion in order to give Mr. Kokonos and the court sufficient notice of the claim. Conclusory and bald allegations will not suffice. Plaintiff's argument that the electronic records stored on a computer may be converted is academic. Plaintiffs still have not identified a single physical or electronic piece of personal property that Mr. Kokonos converted. The who, what, where, and when, and how is completely absent from plaintiff's complaint. Art and Fashion Group versus Cyclops Production. False advertising, deceptive and misleading business practices, General Business Laws 349 and 350. The consumer fraud claim under General Business Law 349 claim requires consumer-oriented conduct which is deceptive or misleading to a consumer in New York. Goshen versus Mutual Life Insurance. Putting aside the territorial issues with a claim by California residents and that the alleged transactions are not anything like the small consumer sales transactions which the statute is designed to protect, the complaint fails to state a cause of action because plaintiffs are not alleging deception. The gist of plaintiff's allegations are that Mr. Kokonos has successfully distinguished himself and the Dick Show from Azunian by calling him a cuck and lampooning him. Mr. Kokonos is not deceiving reasonable consumers into buying his Santa Cuck album by misleading them to believe that it is a work by Azunian or approved by him. There is no bait and switch. In this unique alleged feud, the fans know exactly who is who and whose team they are rooting for. Azunian has not been allegedly damaged because consumers are confused. Lastly, a false advertising claim under GBL 350 claim requires reliance. The complaint does not allege reliance, and plaintiff's opposition papers do not address this failure. But this stream does address Landau's failure. Conclusion: the complaint should be dismissed with prejudice against Mr. Kokonos. Plaintiffs have not requested leave to amend, and the court should not grant them that opportunity. Absolutely not. At this point especially, they don't get to redo. They don't get to start over and say, sorry, we were wrong on everything. We want to try again. Do over, guys. Mulligan. All right, so here's the appendix. This is the Mr. Burger's email. And all of the email addresses are sufficiently redacted. So let's just read this. So, from Dax Herrera to Asterios Kokonos, the subject, forward, Jesse Radden, email to Dax/Dick Masterson as requested through Facebook. The person responsible for making the death rape threats to Jessica Blum just sent me a confession. Might help your case. So here's the forwarded message from Jesse Radden. Hello, Dax. I've been a fan follower of Maddox since sometime in 2002 when I stumbled upon some of his content and have kept up on his website and other content since then. I was also a frequent listener of The Biggest Problem in the Universe in 2014-2015. In May and June 2017, I used several Facebook and YouTube accounts using alternate additional email, Gmail addresses, and sent aggressive and threatening messages, in brackets, death threats, to people, including Jessica Blum, Metal Jess. I do not have a rational reason for my actions. I was simply behaving recklessly and threatening people with no valid reason to be doing so, nor any actual desire/means to do so. I assume he means desire or means to cause harm or to actually legitimately threaten people to cause fear. I hope this email helps in getting everything sorted out for all parties, and I would like to apologize for how I've acted during May to June of 2017. If there's anything else I can do to help, please let me know. Sincerely, Jesse Radden. It's all made up. It's all made up. It's all fiction. I mean, we've known this from the get-go, but it's all fiction. It's all fiction. They've done this entirely wrong from the start. Everything about this case is just a travesty. Fish Munster asks, is autism a valid defense in Mr. Berger's case? Maybe it is. The lack of intent, it'd be hard to actually convict him of any sort of crime that he did there because there's no imminent threat, right? And we'd have to know that Maddox and Blum contacted law enforcement. That would be really damaging to their claim if they didn't. But Wolf Badger asks, how useful is that email? Couldn't Landau argue anyone could have written it? I mean, maybe, except that we have an email address. We have a first and last name. We don't have the email address, but the lawyers do. The lawyers do have the email address. They could supply it to the court. They could subpoena this person. They could bring them in to testify under oath. This is, if it has to be done, this would be extremely helpful should this get past the motion to dismiss. But even in this portion, it should be at least somewhat helpful for the judge to see, look, everything they've done, like every single thing they've brought up is either not actionable on its face or it's done by someone else, including these things, which were already under different pseudonyms. And shockingly, Maddox hasn't alleged that Dick and Asterios created dummy accounts to do this, because that would have been a way to kind of get past some of these defenses as well. Well, on information and belief, they created these sock puppet accounts to do it, but they don't allege that at all. So this should be extremely helpful. But again, it just goes back to the main thing. This is all fake. It's all fake, not in like the long running conspiracy that this is a long con by Dick and Maddox. None of that. This is all Maddox's fiction. Maddox's best written story of his entire life is this lawsuit, in which he creates a world where the law is the opposite of what it is, and a world where the facts are completely the opposite of what they are. Fish Monster says Dick has a proprietary algorithm that enables him to weaponize and direct autism. Yes, absolutely. He also has, I will say, I have been, what are you doing in here?
I want to know if I can have some of that orange drink that you bought.
Yeah, go talk to Mom about it, please.
Okay.
Sorry, that was my daughter. So, yeah. Anyway, guys, this has been a fantastic stream. Thank you to Greenberger. Thank you to Greenberger for bringing out the comedy and giving us a moment of pause and giving my heart a break from last night's Rageathon. I think I'm gonna wrap up the stream. If you guys have any questions here, please drop them in the next couple minutes. Jason Benaim says, "Give her the orange juice." Yeah, she can have it. She can have it. Ashley Princess, give us some orange juice, please. Guys, can you? Oh, thanks, pal. Oh my goodness. If you have any questions, drop me just a couple. Drop them now, and I'm going to wrap it up in just a couple minutes here. Patreon.com/orange juice. Yes, free the orange juice, free the children. Is this the biggest train wreck of legal documents you've ever seen? Absolutely. Absolutely. I mean, you hear about bad cases, but to like stumble across one in the wild that is like evolving as it goes, and the fact that Landau hasn't been fired yet, is this all just comedy. $5 to support Little Rekieta's orange drink. Thanks, Eat Dead Bunnies. Oh my goodness. Clay, no. You're never good to drive. Can you even reach the pedals? Hoodwink says, buy her a barrel of juice with this donation. I will do that. I will buy much juice. Is it possible for an anti-slap suit to be filed in California as a response to this New York LoLsuit? No, Tabmock, it's not. But it is possible to file an anti-slap suit in New York. It's just harder than in California. So I assume when this is all done that the respective legal teams will be looking at those options and the validity of them. But yeah. When is the next video stream? Well, now I'm not sure. I think the next document is due on the 23rd. This document was technically due by Thursday. So, Anthony Tupin, get that kid some juice. Good stuff. Medium pulp. Hey, Tony, how's it going, buddy? Long time no see. We should chat. Anyway, the next stream will be sometime in I think in about 10 days, maybe sooner. It really depends on if documents look like they're going to drop. Also waiting on the Google documents to drop. Also waiting on movement in the trademark suit. Let's all drink some OJ. 2 for raising a polite child. Good on you. OJ is innocent. Kmart says you should do more of these, not in the middle of the night. I'm looking at working that out. I know my nighttime streams are really late for people, especially on weeknights. So I'm gonna see what I can do about that. But it's all a matter of working it in with the family and bearing in mind that my wife and kids are the most important things to me on this earth, and so I can't interfere with that too much. But I love the fact that you guys all come and watch, and I think now's a good time to wrap it down. Apple juice because OJ will kill you. Oh my goodness. I am 100% in favor of apple juice. I will drink orange juice, but apple's my go-to. Apple's my go-to. So anyway, I'm going to shamelessly plug my Patreon one more time. Patreon.com/Lawsplaining. If these videos are hard for you guys to watch because of how long they can get, and you want an audio version, you can find me on iTunes and Google Play. Just search for Lawsplaining. You can also find me on SoundCloud if you search for Lawsplaining or Rekieta Law. Clay, you can't. Are you going to tell your kid that you made a lot of orange juice money because of her? Absolutely, I will. She'll take great pride in that. But yes, so check me out on Patreon, check me out on SoundCloud or Google Play or iTunes. Subscribe to my YouTube channel if you haven't. We don't just cover the LoLsuit here, although it's one of the most fun things. There's lots of other legal topics that we go through. Anyway, thank you so much, guys, for joining me. I'm gonna let the stream wind down, and I will see you next time.